What's up, everybody? I'm back with part 4. I'm pretty sure it's part 4 of Kathleen Zellner's petition for review on behalf of Stephen Avery to the Supreme Court of Wisconsin. We're going to jump right back in. Stephen Avery pled sufficient facts to establish that Bobby Dassey had a motive for the murder. In Stephen Avery's third motion, he alleged that the motive attributed to Bobby for Teresa Halbach's murder could have been sexual and provided evidence supporting this. Namely, the suppressed evidence from a computer that was in Bobby Dassey's bedroom. Further, Stephen Avery supplied evidence showing that Bobby was the primary user of this computer, according to his brother Blaine, whose affidavit Stephen Avery attached. Stephen Avery also showed that Bobby lied to police about the location of the family computer. Stephen Avery also showed that Bobby Dassey lied to police about the location of the computer, claiming it was in the living room, but the crime scene footage showed it was in his bedroom. Stephen Avery supplied this additional evidence to the circuit court in his third motion, even after the Court of Appeals had previously acknowledged the potential materiality of the VLCD in proving a third-party suspect. The circuit court's finding and the Court of Appeals affirmation, contrary to its prior finding that the VLCD could serve to show Bobby's motive if Stephen Avery supplied direct connection evidence, that Stephen Avery has not established the motive element of Denny, contrary to Wisconsin law. Analysis show that the standard for fulfilling the motive element of Denny is not overly burdensome, especially when there is strong evidence of a third-party perpetrator's direct connection to the crime. Stephen Avery presented far more evidence than is even required to suggest that a third party actually committed the crime. The lower court's failure to consider the Denny prongs in the aggregate and their erroneous imposition of burden of substantial certainty on Stephen Avery's motive evidence to prove beyond a reasonable doubt that Bobby Dassey conducted each shirt is reversible error. Bobby is the only person who has been identified as having taken unlawful possession, theft, of the victim's vehicle and had an abundance of violent porn of young women on the computer in his room, for which he has been described as the primary user. Combined with these damning facts in his role as the primary eyewitness against Stephen Avery at trial, Stephen Avery has offered even further evidence of the motive with the Thomas Sawinski evidence, because it shows that Bobby Dassey had possession of Teresa Halbach's vehicle. If not sexual, Stephen Avery even offered another potential motive for Bobby Dassey. After obtaining the Thomas Sawinski evidence that Bobby was in possession of Teresa Halbach's vehicle, a vehicle that he unlawfully obtained, it is only logical to conclude that Bobby's motive could have been theft. The Court of Appeal contended that the theft motive was not properly pled in Stephen Avery's motion, but it was the submission of an eyewitness account by Thomas Sawinski that he saw Bobby Dassey in possession of Teresa Halbach's vehicle after her disappearance. Thomas Sawinski supplied sufficient detail that this was a theft. Stephen Avery's evidence satisfies the direct connection element. The Court of Appeals, in an argument that strains credibility, claimed the RAV4 that Thomas Sawinski witnessed was not necessarily Teresa Halbach's vehicle. Wow. In order to dismiss Stephen Avery's direct connection evidence, there's just a whole bunch of random RAV4s floating around the area on that day. Specifically, the Court of Appeals disputed that the RAV4 belonged to Teresa Halbach, finding the Thomas Sawinski's affidavit. However, only stated that Thomas Lewinsky saw Bobby Dassey and another individual pushing a blue-colored RAV4 on November the 5th, 2005. Apparently, the appellate court believes that Thomas Lewinsky was required to obtain the VIN number of the RAV4 that he observed to rule out the complete improbable scenario of Bobby Dassey pushing another blue-colored RAV4 up to the Avery property. Ridiculous. On November the 5th, 2005, in the early morning hours. Unlike the Court of Appeals, the Circuit Court correctly acknowledged the Thomas Lewinsky affidavit taken as true for the purpose of this motion directly links Bobby Dassey to the possession of Teresa Halbach's vehicle. The Court of Appeals rationale is incorrect as it did not take Stephen Avery's pleadings to be true. Applying the common sense approach here, which nobody has, applying the common sense approach here, the Thomas Lewinsky evidence provides the direct connection that is Bobby being witnessed in possession of Teresa Halbach's vehicle to Bobby having committed the murder of Teresa Halbach and planting the evidence to frame Stephen Avery. The RAV4 is a material piece of evidence into this crime. Here, the Circuit Court admitted that Stephen Avery established Bobby Dassey's possession of the RAV4, but it created other explanations other than acknowledging that Bobby had possession of the RAV4. I think it said, it's probably going to talk about it here, like he could have possibly been helping his uncle cover up the murder. Sometime following the murder of Teresa Halbach, Bobby is now connected to the material evidence in the Teresa Halbach murder case. The Denny test only requires an inference that Bobby is directly connected to the murder of Teresa Halbach, nothing more. By having possession of Teresa Halbach's vehicle after her disappearance, the inference can certainly be made that the Thomas Lewinsky evidence is being offered as evidence of the missing piece of the direct connection between Bobby Dassey and Teresa Halbach's murder. Contrary to the lower court's position, Stephen Avery does not need to prove Bobby Dassey's guilt for the murder beyond a reasonable doubt. Stephen Avery showed that there is a reasonable probability that presenting Mr. Avery's newly discovered evidence undermines the confidence in the outcome of Stephen Avery's trial. Stephen Avery has adequately shown how newly discovered evidence would have changed the outcome of his trial. The new evidence would have allowed the defense to impeach Bobby Dassey's trial testimony during his closing argument. Prosecutor Ken Kratz emphasized the importance of Bobby Dassey's testimony and vouched for his credibility. Bobby Dassey would no longer be the unbiased witness described by Prosecutor Ken Kratz. Further, the forensic evidence would have been viewed as planted out or at least tainted by being in the hands of a third party. With this new evidence, the defense could have argued that Stephen Avery returned to his trailer, Teresa Halbach left the property in her vehicle, and Bobby Dassey followed her, got her to pull over and assaulted and murdered her. At some point, he planted the RAV4 on the Avery property and proceeded to remove and plant electronic devices, the key, the bones, her clothing, her DNA on the bullet, and Avery's blood. The Thomas Lewinsky evidence, when viewed in the aggregate, including all of the false statements made by Bobby Dassey to law enforcement at trial, would have provided a reasonable probability of a different outcome at trial. Whether the Court of Appeals improperly affirmed the Circuit Court's decision to deny Mr. Stephen Avery an evidentiary hearing, standard of review. Whether a defendant's post-conviction motion alleges sufficient facts to entitle the defendant to a hearing for the relief requested is a mixed standard of review. First, reviewing the court determines whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief. This is a question of law that is standard. If the motion raised such facts, the court circuit court must hold an evidentiary hearing. However, if the motion does not raise facts sufficient to entitle the movant to relief or presents only conclusionary allegations, or if the record conclusively demonstrates that the defendant is not entitled to relief, the circuit court has the discretion to grant or deny a hearing. The reviewing court reviews a circuit court's discretionary decisions under the erroneous exercise of discretion standard. Stephen Avery alleged sufficient facts in his third motion entitling him to a hearing. However, the lower courts disputed those facts instead of taking them to be true. The circuit court must determine first whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief. Both the circuit and the Court of Appeals improperly attempted to weigh Stephen Avery's facts with speculative theories unsupported by the record rather than accepting his facts as true and determining whether they were sufficiently pled to warrant an evidentiary hearing. The Court of Appeals offered the theory that Thomas Winsky saw a different RAV4 and not Teresa Halbach's RAV4, as he claimed. Both courts failed to conduct any analysis of whether Mr. Stephen Avery pled sufficient facts to warrant an evidentiary hearing on his newly discovered evidence. Instead, the lower court weighed Stephen Avery's evidence as if it had already been presented during an evidentiary hearing. The lower court's analyst begins to weigh the evidence it inevitably misstates, and the uncontradicted facts a petitioner asserts are not taken as true. The need for an evidentiary hearing becomes apparent. In Stephen Avery's case, each court has assumed as true a different theory or a different part of the theory than the other. No court has looked at all of the evidence cumulatively to determine the likely impact on the defense, on the prosecution's case, or on the jury's verdict. An evidentiary hearing is nothing more than an intermediate step toward the objective of being granted a new trial. It is not an end in itself. The evidentiary hearing is a form to prove allegations in a motion for post-conviction relief. Stephen Avery's motion for post-conviction relief states that he is set to prove if he were granted an evidentiary hearing. An evidentiary hearing would provide Stephen Avery with the opportunity to prove his pleaded claims that he is entitled to a new trial. If Stephen Avery's motion contained all of the proof necessary to show that he was entitled to a new trial, he would not need an evidentiary hearing. Because Stephen Avery has alleged sufficient facts in his motion that, if true, would entitle him to relief, yet the lower courts keep denying him the opportunity for an evidentiary hearing, Mr. Stephen Avery asks this court to revisit what is required for an evidentiary hearing. Conclusion. Stephen Avery's case raises three critical issues on which this court's guidance is needed. First, Stephen Avery presents this court with an opportunity to correct the lower court's misrepresentation of law in what is required to bring forth newly discovered evidence. Second, Stephen Avery presents the court with an opportunity to return to the issue of the extent, motive, opportunity, and direct connection that is necessary to satisfy the Denny party suspect for admissibility. Third, Stephen Avery presents this court with the opportunity to correct the lower court's misrepresentations of the pleading standard to obtain an evidentiary hearing on Stephen Avery's claims. Fourth, Stephen Avery presents this court with an opportunity to grant him a new trial in the interest of justice. Stephen Avery respectfully asks this court to grant him leave to appeal the issues raised. And then the next bunch of pages are just autographs, signatures, and stuff of all the lawyers involved. This is very well written. This pokes a bunch of holes in a bunch of different things. It's going to be very interesting to see what the Supreme Court of the state of Wisconsin states when they review this and come back with a decision. What do you think? Let me know. Leave some comments below. Thank you for watching all of these. If you've made it through all the parts, Hope you're having a good day, and I'll see you again soon.